there are any problems, and then we can discuss them. I think we looked at this one yesterday. Okay, these are the claims from another person. So, a consortium aimed at eliminating COVID-19 and other through comprising by wind, seed pads, water, 4 parts honey, 1 part ground lemon.
About the quantities. About the quantities, she could have just, the author could have elected to just give the ingredients, say cloves, ginger, lemon, and all that, instead of being very particular at that very early stage. The author should have avoided making it a medicinal production. So she could have just called it a beverage or something in those lines. But the moment you make it medicinal, you open yourself to all those processes that govern medicinal creations. And it's very difficult for that invention to see the light of the day, at least in the earliest. And then secondly, at this very early stage, I don't think it is good to be very particular about the amount of ingredients that you are going to use. You can just name them instead of being very particular about the sizes of the ingredients. Because if someone else comes with maybe 2 parts of cloves or 1.1 parts clove, it is still the same thing with the same effect, but it's a totally different invention altogether.
Yes, I think to me is the structure of the claim. Rather than the whole sentence, it lacks the structuring, like we said.
Yeah, I think the first claim is loaded. The content might be useful, but I think the inventor is lost we talked of the transition, the body. I think at the beginning we see the body actually maybe the function of the dawa, and then towards the end we look at the composition, which I think should have been maybe the other way around. I think at the transition level we should have seen what is comprised of the dawa, of the concoction, before we look at maybe the function of it, maybe towards the end. So I think that first claim is actually loaded with a lot of information.
As my other colleagues are saying, the claim is loaded, and it's very specific. You know, I'm imagining implementing this at home. How would I know 16 parts of honey? What is that 16 parts? 4 parts, 1 part. That's so difficult to implement at home for anybody. A layman or somebody with a scientific mind would not even be able to implement that one. So that specificity probably weighs the claim down.
Okay, from our yesterday's understanding, I think I know these were the assignments that were done before yesterday's exercise that we revised. So that is why we are still talking about how to introduce a claim. We are still talking about the preamble, the comprising. So I think, and when you look at that introductory part of that, it's part of an abstract, or maybe it should be in the description, not actually in the claim. And I know if we did our revisions yesterday, we could not be no longer seeing these ones, because we now know how to introduce, how to list the specific, and how to add additionals that we want to claim as embodiments. So I think this one was done before yesterday, because we have already done how to introduce the preamble, the body, and how to put all those things together. To me, it looks like a composition of somewhere. It's a whole composition. It's an essay, yeah? Yeah, it's not a claim.
So what can we do to this claim to turn it into a proper claim? How can we reach that?
It's like starting all over again. Yes. We now stay, is it a beverage, or maybe for mine, I said it's a natural cocktail composition, and then a comma, comprising. You now list those things: lemon, cloves, or cloves, I don't know which one, ginger, honey. Those was now should be in claim 1 as the composition, yeah.
told you yesterday, cranes are, they don't know what? They are crafted. They are crafted not. So the first draft that you come up with, you may have to revise it several times before you arrive at an optimum one. So how does it read now? Does it look like a crane now? In terms of formatting? Yes. Yes. Then you can start playing about with the other words. You're saying you would like to substitute the concoction. There are those who would want to call it instead of cocktail, you call it a beverage. So when you have prepared your claim, the first one, don't worry about the correctness of things, but just put things there. Then you'll be able to be organized and redraft that claim, checking again the grammar, weighing every one that you have used. Is that one necessary? If it's not necessary, you throw it out. Okay? If it doesn't capture the invention as in the inventor's mind, look for a substitute. Look for another name. Okay? And again, sometimes, even the inventor may not have figured out something. There is a lot that happens when now the inventor is talking with the person who drafts the pattern. Sometimes you have to stop midway drafting just to get clarification, or to even ask a question or challenge the inventor's mind. For him, in his thinking, he's thinking of a cup, a beverage, 1 cup of the beverage. But if you're thinking in an industrial manner, you're thinking of the commercial scale of the invention. That is when you find, for him, he'll tell you, I added, 16 grams of ginger to 16 grams of lemon juice, okay, or 15 mils of freshly squeezed lemon juice. But then you have, as the pattern drafter, you want to capture as much scope as possible. You want to ensure the maximum protection for his invention. So you have to challenge the inventor's mind to open up and think beyond that 1 cup of beverage you prepare. Sometimes they have meant to go back to the lab and test. If we put, let's say, we started with 16 grams. If we put 50 grams of ginger, will that beverage be better? Or is it still a beverage that can be consumed? Does it still fit within the invention? Then you have to change your wording to capture that invention. So that's why I say cranes are crafted, not drafted. So you can rearrange again. You need to meet the requirement and the format that is necessary for the invention.
Oh my goodness. Thank you. Then he had claim, there was claim number 2, a method to brew remedy COVID-19, where for COVID-19 wherein The sentence is not even leading, eh? Isn't it?
Just go back. Go back. You know, I don't think that will, the claim will pass.
Hmm?
Flus. What is the author talking about when she says flus? That is not the spelling of flus.
The spelling of? Oh, flus.
Yeah. So ab initio it fails, eh?
Do you have plural? Do you have frus? Or it's just flu?
There are very many flus, so I think it is not just one flu. There are many. COVID-19 being one of them. So
Yeah.
I think flus, unless he gives us the correct spelling of flus, I think, actually I was the drafter of that, and therefore I'm taking the corrections right here.
Okay.
So I know I wanted to talk of other flus, and then later on we were told that the moment you talk about medicinal terms, then you are actually subjecting yourself to more scrutiny. And I know that in future I'll avoid including that COVID-19 and other flus. But at the introduction, we were told that everybody has, during COVID-19, we did things. And a few brews here and there, concoctions, beverages, and so on. I also oppose the use of the word beverage, because a beverage is just anything you can take. You can walk into a shop and buy it and drink it anywhere without caring whether it has any other effects, side effects. Now, what I understand is that something like a few of those parts there might have negative effect to your health if taken too much of it. Beverage is something I go, in the morning I take a beverage, maybe after taking lunch I can take another beverage, supper I take another one, I wake up at night I feel not good, I take another. So I think beverage can also be opposed in some way, but we are not sticking to that. This is an example which we want to know, how do you draft? Because in future when we draft, especially I come from TVET, we have been doing these things in the totally opposite way. So today we are learning so that in future somebody comes up with an invention. Now we can draft something that you correct us only once and then it is home. Thank you.
Just for participants, just a clarification with regard to medicinal stuff. It's not everything that is controlled by Pharmacy and Poisons Board. For example, you have supplements. Yeah, they have some healing power. So they are not, you don't take them to Pharmacy and Poisons Board. Pharmacy and Poisons Board, they deal with chemical products, pharmaceutical products. Yeah, so those are what they control. You cannot sell the normal pharmaceutical products. You have to register. You have to go through the registration of the Pharmacy and Poisons Board. But herbal things, Pharmacy and Poisons Board doesn't deal with herbal. They don't regulate. Although now for like things like beverages, for you to put them in the market, you have to go to KIPI for you to get the mark for KIPI, for you to enable for you to put them in the market. Yeah, but not everything is controlled by Pharmacy and Poisons Board. So don't fear. I mean, for management, there are so many things that we manage. I mean, like the stuff that you're talking here, they are commonly used. You go to Carnival and these other places, even hotels, you unapewa dawa. I haven't taken them to Pharmacy and Poisons Board. Yeah? They are normal, and it's food. We take it as food in our normal daily life. So don't fear about Pharmacy and Poisons Board because you've mentioned the management of COVID-19. And we take a lot of supplements from India. They don't go to Pharmacy and Poisons Board.
I think, as you can see, I've tried to propose several words there, which you can use as preamble. Really, there is 100, so several options you can come up with as the nini, and doesn't really need, because when you look at all these, they revolve around a certain category of inventions. Basically, those that are made from extracts from plants. Let's say. Remember what we said. You need to use as few words as possible. If this herbal composition, okay, is aimed at alleviating flu, why do you want to be specific about COVID? Because anybody with even the other general flus, when you take, the dawa, it helps relieve some of the problems when you have that infection. And to me, then I would try very much to restrict myself about when I'm putting the preamble, adding so many words. Okay? I would limit myself to the basic description or identifier of inventions that belong to that category. Herbal teas, herbal beverages, herbal extracts, comprising. Without necessarily restricting myself to the COVID flu. And as I told you, one claim can be drafted in many different ways. And I think you're realizing this. Now, people came from different approaches when they were drawing up that claim. Claim 3, I think there wasn't the method by product claim. And I think at this point, we break for tea. And I would like to wrap up this session. We may not be able to go through all the other claims in plenary. But I think now you can start appreciating the depth of thinking that you have to get into when you're drafting the claims, including even where you have needed to weigh out is the inventor telling you everything about the invention? Because he'll come you with a limited invention, the embodiment he made in the lab. But you've got to read the inventive concept, because that is what you would intend to capture in the claims. And this is why these issues of being so limited, because he brings to you an embodiment of the invention. That's what is explained. But you've got to read the inventive concept in that embodiment. And that is the invention that you want to capture when you're drawing up the claims. Okay? Claims are very important. That is why you have even to weigh each and every word that you're using. It will have a significance when it comes to defining the scope of the invention. Because what is claimed is what is protected. What is not claimed is not protected. Even if you describe it and it's not in the claims, that invention is not protected. The key thing is come up with the claims or set of claims that capture the invention in the broadest way that you can. Given what is available to the public at the time you are preparing to file the application, the patent application, because that would also limit your scope. How much Now where should you go? The literature that you have found, you've got to evade, because that will be used to destroy the novelty or the inventive step of the patent application. So be governed by the prior art, go for the maximum protection, the maximum scope of protection. Let the examiner push you down, because the examiner has a responsibility. One, to protect the public domain. And I'll talk about public domain in my next presentation, when we are looking at where do you get prior art and how to access patent information. So for now, I think we can break for...
Okay, I think, thank you very much for this very hands-on session. And I think now as we move forward, we are now getting closer to really writing and writing patent, given this knowledge that we need to be very aware of what we are doing, and also be more practical in how we are going to deal with the patent drafting. So I would like us to go to take our tea for 15 minutes. So we'll be here at 11:21 a.m. So, and I've actually been requested to request, especially those coming from the different institutions, to select one person who will give us the vote of thanks when we'll be closing later. So let us take the shortest time possible so that I will be guided on what next by the facilitators. And as we get closer to the close of business today. So thank you very much. Okay. So 15 minutes. So our tea is actually served.
And now that you are ready to file a patent, and in this particular case, you were taken through patent filing procedures in Kenya. Now, today we are dealing with the international filing system. So as we continue to learn, first of all, we were taken through procedures of filing in Kenya. If you wanted to file an application at KIPI, and that was a national patent application. Now today we are learning on how you want to, if you want to file a patent application abroad, assuming you want to venture or penetrate an international market or in a foreign country. So there are actually 4 routes within which you can pursue that particular agenda in terms of filing. First of all, you have the national route, as it were, first of all, for purposes of filing the national application. At the same time, KIPI receives applications for the regional filing. In this particular case, is a receiving office for ARIPO, which is the Africa Regional Intellectual Property Organization. It also acts as a receiving office for the PCT, which is the Patent Cooperation Treaty. And so you load the applications, you can load the applications in KIPI, and the KIPI can forward for you so that they can be processed in those jurisdictions, the regional office and the international bureau. You can as well file directly in ARIPO, which is headquartered in Zimbabwe, and that is the regional route if you want a regional patent application. First of all, I think I want to mention that ARIPO is a regional organization which deals with intellectual property and is responsible for about 19 English-speaking countries. There is one for the French-speaking nations, which is in Yaoundé, and that for the time being we are not dealing with that because they file the applications in French. The other alternative, the 4th one, is of course the international route, where you file the application at the World Intellectual Property Organization division called the International Bureau. So those are the 4 routes. First, directly to the International Bureau, or directly to ARIPO, or file through KIPI and show interest that you want to file in ARIPO so it can be forwarded, or directed the PCT to PCT application to the National Bureau. So why file abroad? We mentioned at the beginning that patents are territorial. That is why if you file an application in one country, it doesn't protect you in another country. So that is the reason why you want to get into those countries so that you can obtain a patent. Okay. This particular procedure helps companies to secure, market for monopoly for their products. Okay, and you can also enjoy what we call licensing to foreign firms in the process. So I've mentioned about the constitution of ARIPO. It covers 19 English-speaking countries, and it's based in Harare. And by the way, it was in Nairobi before it moved there around 1978 or 79. So you should also be aware that we used to host ARIPO before it went. And it administers the Harare Protocol on patents and industrial designs. The procedures for ARIPO, we have mentioned that KIPI is a receiving office as well as a designated office. Designated office means that any ARIPO patent application can designate Kenya. Once an ARIPO patent is actually examined, an applicant may want protection in Kenya, for example. So they will designate, because out of the 19 countries, you can select the countries where you want your protection to take effect. So a patent application filed in Kenya must be filed in ARIPO within 12 months so that you don't lose what we are calling the novelty and also the priority dates. Who may apply? It can be the inventor or his representative, and usually a patent agent in this case, using the ARIPO form number 3. Further, like I mentioned before, you can file directly as an individual or using your lawyers to file the same in ARIPO. And those lawyers must be recognized by ARIPO, just like we were mentioning about the Kenyan patent agents who must be admitted by KIPI. And we were talking about the lack of patent agents in this region. And if you want to, let's say, represent a client, maybe in filing an application in ARIPO, you must also get admitted to practice under the ARIPO protocol. So ARIPO, what it does is examines all the applications that are sent to their office to establish whether they meet the patentability criteria which we discussed in the course of the training, which was novelty, inventive step, and industrial application, and actually grants patents on behalf of member states. However, there is a window whereby member states are asked by ARIPO whether they can object to certain claims that may have been protected, because like in Kenya, any application that is dealing with methods of treatment will not be allowed. And all applications are filed in English. What are the advantages? It is the advantage is that you file a single application which will be examined as one, and you get one patent which will be applicable in all the member states, if that will be accepted by the national law. It is one receiving office, and you will see later on about the difference between regional applications and the applications under the Paris Convention, where you will be expected to file an individual application of the countries you are interested in. And you use one set of fees. You only pay the fees in dollars to one office, rather than going to individual countries to see, to pay in their currency. So what is PCT? It's an international treaty facilitating the processing of patent applications internationally. And in this particular case, at the moment, as of April, there are 156 contracting states, those who have signed to join ARIPO. The PCT, the treaty. For Kenya, we joined sometimes in 1994. So we are bound by the treaty. We can use the treaty. It's very efficient and advantageous procedure for users of the patent system, because you lodge one set of documents in one office, and it will cover all the member states of the, it's like you have lodged an application in each of the countries. There are 156 of them. The patent system really is a filing system. There is never anything like an international patent. It is just a patent filing system, and it's not a granting system. They never grant. The ultimate granting authority is, vested on the national, at the national phase to the various, contracting states. So it consists of an international phase, because once you file an application at the International Bureau, there are procedures and processes that go on at the international phase before they finally come to the national phase. So there are two phases in this particular application. So what I was saying was the decision of granting patents is taken exclusively by the nationals or regional offices where applicants wish to designate protection. And this is, in a nutshell, the geography of spread, a vectorial spread of the member states of the PCT, contracting states. And that is the PCT timeline. What I'm going to say here, to briefly explain, is if you look at the timeline of the PCT application, there is the filing of the local application at the start. I'm sure, I wish I had there, 0. At 0 months, I think at 0 months, you find that the application is filed at the national phase. And if you have to file an international application, you have 12 months within which to do the same. Once you file an international application, it is given the international filing date. And within 16 months at the international level, a such report will be established, and a written opinion on whether this patent application meets patentability. At the 18 months, it is an international practice that all patent applications are published just like we did in Kenya, after every 18 months from the date of filing. But in some situations, there are optional requests for supplementary international search. Some people may want to move very fast in terms of, getting granted their patents which have applied, so they request for supplementary searches. There is also another option to file a demand for the international preliminary examination to examine in details as to whether they can, be patented, a report on patentability. And you will see the types of reports that are released by the international search authorities in the course of the presentation, which indicates what they do, because the body of the search report, the written opinion of the side, the documents, you'll be able to see the importance of each of those aspects. And so the beauty of this particular thing is that the PCT will allow all applicants up to 30 months to enter the national phase of the designated states. As you can see, those arrows at the end, they indicate that if you want to enter the national phase, at that point, you will have made a decision based on the reports, whether indeed it is worth going into those particular markets. The traditional system, like I said before, you file an application like today, within 12 months you should be able to have filed in all the countries around the world, and physically or literally physically going there, even you don't go use a lawyer in each of the countries. So you can imagine getting 156 lawyers of member states of the PCT if you are using the Paris Convention system of filing. It means you will file a local application within 12 months, is followed by multiple foreign applications claiming priority under the Paris Convention. Multiple formality examination. I think we will be able to see that at the PCT level, the international level, they will be able to conduct one formal examination, check the fulfillment of the requirements, one such report, one international application, one international preliminary examination report, and the various prosecutions that proceed. But in this particular case, where you have multiple applications, you have so many of those examination reports which may vary from country to country. There will also be need for translation, because as we speak now, most of the countries like Japan, China, Spain, and most of the countries in South America use different languages: Spanish, Portuguese, Chinese, Japanese, Korean. So in fact, in a nutshell, you will be required to file translation fees within 12 months in each of those nations. So that is why the PCT became very important. It's a unified filing system consisting of filing and processing of a single application with legal effect in all the PCT member states, 156 of them. One application having that particular effect. It provides information on the potentials or patentability of this particular invention before the start of the national procedure, so that if the examination report or the information on patentability is not very strong, you may want to withdraw, because you don't want to proceed if, like yesterday, you saw the prior art indicating that all the elements that were marked X exist in the prior art. You may not proceed because it doesn't make sense, because it doesn't fulfill the requirements, because the novelty has either been destroyed or in other words killed by the existing patent information. Publication of the international application is done together with the search report, and you will see how that search report looks like. And like I said, the applicants have up to 30 months before the start of the national phase, based now on this search report. Now, the importance of this particular procedure is that you defer the costs. Like you saw how we were filing everything within 12 months. Cost of translation, processing, examination, legal fees for purposes of patent agents. But in this case, PCT provides an opportunity for applicants to defer initial costs associated with the entry into the national phase. The cost of translation into other languages, local patent agents, local patent office fees that are charged. So when are these initial costs incurred? If you look at that, I'm not sure that's very clear. So the traditional system file a local application within 12 months. You can see you have to file all those applications in each of the member states. Fees, translation fees, office fees, and local agents, just like I said. But for the PCT, you have all the time. If you look at from zero, filing a local application, there you have milestones within which you can be able to make a decision whether to go to the national phase, up to 30 months. And in some situations, there are countries who give up to 32 months, depending on the national law. So you can see, you can defer the cost and make even informed decisions on whether it is, there is any wisdom, first of all, in going to most of these countries. You may decide not to enter national phases in certain countries for some reason, depending on whether your technology will most likely be needed there, because some of the inventions may not necessarily be required in other jurisdictions. Like if you invent something on malaria, for example, it wouldn't be very wise for you to say you want to file a patent application in Europe because there's no malaria there, because of the climate and other things. Or even equipment for skiing, you cannot bring them to Africa, there is no snow. So some of the things that happen within the processing will inform when and where to file, whether you are going to have the market. After all, the patent system was to give the exclusive rights to sell this particular technology. So where are you going to sell? So does it make sense to invent something that does not sell and or prevent that, because it's expensive? And I think there's something I saw yesterday about somebody who may want to intend to file applications, it's about, let's say, 200 countries. It is estimated that you can spend up to $1 million to file an application in about 200 countries around the world in terms of managing the fees and processes of all that procedure in all the countries. And that is extremely expensive. So one has to consider the cost of management of that, because you need to manage the issues of infringement in each of the countries, filing fees, maintenance fees, processing fees, and so forth. So it is an extremely a very expensive enterprise to engage in. So usually the PCT applications are received or filed in the receiving office, like I mentioned before, and we normally say receiving offices are those patent offices that are mandated. Like, for example, in Kenya, it is KIPI that does that, because we are mandated by law. There is no other authority. There is no other authority in the country that is mandated to receive a patent application on behalf of the PCT. And when we receive, just before we forward, we conduct formality checks to ensure the application meets the international standards. And we accord or refuse the international filing date. We can accord the filing date if they meet the requirements, but we can refuse to give them an international filing date if they do not. Until such a time when the corrections has been filed, we would be able to give the international filing date once the corrections have been submitted. And when filing, one will specify one or more international search authorities or examination authorities. Because, and actually the form, which I'm not going to project, if you want to visit, I want you to look at your own time, the PCT application form at the WIPO website. It's a long document. I saw it was around 24 pages. But of course, 13 are meant to be filled. And that's why we could not even bring it here. There's so much information that is required. 13 pages is the real form, and then the rest of the remaining pages, around 11, is guidelines on how to fill. So one must specify where you want to do the search, because we have international search authorities, and I think there are over 10 of them. And such authorities international search authorities are patent offices which have documentation up to over 70 million documents since 1920. Those are the authorities that have capacity to conduct such an examination on behalf of the member states. And of course, they charge a fee. So the wisdom here is when you are searching, when you are specifying one, you'll be guided by the fees they charge. Like the European Patent Office is the most expensive, although they have the largest documentation in the world. So you of course, you have to take into account all that. And so when you are selecting, you have to indicate, there are boxes in the application form, which authorities. And for some strange reason, we was very surprised. I think when we were doing our case for Kenya, there was a time when we had put China. I think somebody's sneaked in China for some reason, we do not know, because we don't examine the application in Chinese. I think it was a mistake, what normally people normally say, computer error, but there was no computer at that time, but somehow it was sneaked in. If you look at the Kenyan office, there is something where they were saying one of the such authorities would be China, and that was very strange to me. We also collect fees on behalf of WIPO. Of course, you do some checks and forward the documents, and of course we charge our transmitter fee, and that is why we're saying collecting fees for the International Bureau. The international search authorities are listed there: Australia, Republic of Korea, and you can follow them up. There are many of them. Nordic Patent Institute. The search report gives, like I did, private documents that relate to the patent application. Normally, it also indicates the classification of the patent. It shows the field of invention. They are classified according to the field of invention. They include the technical areas that have been searched, those that relate to lack of inventive step and so forth. And this is now the structure of the international search report. If you look at that particular drawing, on one column there is a category of documents. X document means a particular document that has been identified has a relationship. And if you look at the far end on this side, relevant claims, the X document means it has a relationship to these particular claims. X means it can destroy novelty. That particular innovation you are proposing lacks novelty based on this document. That means claim 7, 9, and 11 are destroyed by this document because of novelty. That means they tend to focus on what you are proposing. So unless you amend, that document is dead on arrival because it seems to be anticipated. However, the other claims may be okay. I mean, but if claim 1 is independent claim, that still stands. These ones you may be forced to amend. Maybe just get rid of them, delete, or don't claim altogether and try to wriggle out so that you can be able to get the patent. The Y document compromises the inventive step, that it is obvious based on this particular innovation. If you find a Y document, it means the invention lacks what we call inventive step. It means it is obvious to the person skilled in the art, and therefore will also be maybe invited to amend to overcome the objections of that particular requirement. The A document is the general state of art. It's just general. It does not affect your application. It means this one is just basically discussing the generals in the field. It does not compromise, and therefore it cannot even block the grant of a patent. So that is basically the structure of the international search report. And when you get it, you consume it as an applicant, compare with what you have, where you need to make corrections, you do. So when they highlight the various claims, look at those claims vis-a-vis your application so that you can be able to make corrections. There is also what we call a written opinion. There is just an opinion which is non-binding on the novelty, inventive step, and industrial application. But it is a very strong basis for making patent decisions. An opinion can be an opinion, just like it's non-binding. I think it is like this, but when you are sitting on the other side, you also think in another way. It is also established during the time of the writing of the international search report. It is made available to the public on the WIPO website, and it is used for making decisions on how you will proceed with your patent. And this is how it is. If you look at that, is the structure of the written opinion. When the international search authorities do that opinion, they give you statements on novelty, inventive step, and industrial application. So when they assess Some of the claims may pass, some may not. So it's upon you as an applicant to go and make amendments based on that. But unfortunately for this particular case, I can see most of the claims, 3 to 16, with regard to industrial application are valid. So, of course, most of the industrial applicability claims are normally, they normally pass. But when it comes to inventive step and novelty, they fail. But in this case, I can see novelty, the only claim that is not novel is 16. So you can as well get rid of claim 16. If you look at that, I'm not sure that is clear. Once you go and look at that, the only thing that is not novel in this particular innovation is claim 16. So if you want a quick grant or patent, you can just delete that particular claim. And then, of course, trying to make amends to the inventive step, because there are quite a number. I see claim 8, 10, and 12 are inventive. The rest of the other claims are not, and therefore you need to make some amendments in order to overcome those particular objections. So the international publication takes place after 18 months, and this is the international norm under the patent system. After 18 months from the filing date. One of the functions of the International Bureau, in this case, WIPO, I think we should be getting used to this now. When we say International Bureau, it is a division in WIPO where these PCT applications are actually produced and processed. They standardize the front page with bibliographic data of the particular innovation, and I think I didn't pick out the page. If you look at you can look at the patent document with this particular data in terms of the title, the abstract, and the name of the inventor, the name of the applicant. They have a specific format of setting out those features in the first page. There is also another publication too. It is normally done in 10 languages because, like I said, WIPO has 10 working languages. Some of them are there. As you can see, Chinese, Arabic, English, French, German, Japanese, Korea, Portuguese, Russian, and Spanish. Those are the international languages that are acceptable at the International Bureau of WIPO. And that is why, if you are a Kenyan applicant, if you want protection in some of these countries, you'll be forced to pay fees for translation in each of them, because when you go to the national office, they will not examine in English if you send it to France, for example. They will want a French document, German would want their German document, Japanese, it must be translated in Japanese, Korea, Portuguese, and Russia, and that is expensive. And that's why even these are some of the things that inform the decision to enter the national office in some of them. And remember, PCT applications are made available through publications. The written opinion, those are found in the WIPO website. The preliminary examination report, examination is an optional procedure, like I said before. You can request the international search authorities and international preliminary examination authorities to look at your application, just to get an opportunity to amend the description, drawings, or address objections raised by the ISA before the national procedure. So you can make corrections before you enter the national phase, because these are guys who raise the red flag on certain areas, maybe lack of unity of invention, lack of clarity, enabling disclosure, and perhaps in some situations, questions of non-patentable subject matter, or where the examiners were unable to search. They will tell you, we have searched to this extent, but we didn't search this. So it's upon you to proceed and provide some clarity before you enter the national phase. And this will result in an issuance of a preliminary examination report, which is not binding, as we said, on the issues of novelty, inventive step, and industrial application. After the end of the international phase, which is 30 months, which we were saying we were buying time, now it is 30 months. PCT applicants may enter the national phase of the designated states. Initially, all the member states of the PCT are normally elected in the application form, which we did not visit. I wish we could. All the member states of the PCT are normally elected at the initial filing. But when it comes now to entry, you will have made decision on where to enter and where not to. And this is now what we are going to call entry of the national phase of the designated state. You designate now. It's like you are selecting. Designate means you tick the box. I want to go to the national phase in this particular country. So as an applicant, you inform WIPO that I want to enter the national phase, maybe in Nigeria, for example, and they will send your application to Nigeria to be examined under the national law. If somebody filed elsewhere and they want to designate Kenya and they want to enter the national phase after 30 months, they direct WIPO to send us a copy of the application to examine under the Kenyan law. And when we find that the application has landed in Kenya, for example, we will subject that application under the national law and look at what the law provides and what the patent applicant is claiming as an invention. So like I said before, there are inventions that may, according to the international research authorities, are inventive and novel. But when it comes to Kenya, we will say, look, under the law, we don't protect inventions that are immoral. They can destroy the environment. Like if you maybe invent a nerve gas innovation or something that used for treating people, and you say this is a method of treatment. So we will reject on that basis, and we quote part of the act that this, under the act, this section, this part of the act does not allow. So the grant of a patent is invested rights of refusal is about the national law. This was what was supposed to be done. Patent applicants must be nationals or residents of one of the PCT contracting states. Anybody living outside any PCT contracting state is not capable of filing an application for the PCT unless you are living in a country which is a member. Assuming Kenya, for example, is not a member of the PCT and Uganda is, you will be forced to go to Uganda and lodge an application there to be able to file an application for purpose of PCT. And of course, the application may be filed in any language accepted by the receiving office. But Uganda, for example, they do in English. But if you go to, let's say, DRC, their language, I think, is French? So you'll file in French. You'll file in French because you have actually moved to their jurisdiction, and because their national language or the receiving language, the language of the receiving office is French, you'll be forced to do the application in French. So those are some of the few things that one must say, and of course, the capacity to file, who may file will be the inventor or the representative, and if it is a research organization or company, they have that power to file an international application. And I'm not sure that was too fast, but that is it. Questions for now, because we. Somebody? Or everything was clear, is it? Or it is a difficult subject matter?
It's not a difficult subject matter, but there is a lot of bureaucracy which is involved in international application. As far as the patent is concerned. was first wondering, number one, what can that procedure be made simpler so that, the parties are so many, start from the international office, that's the PCT, and then you come down to the national office. And even at the national office, there are a lot of things which need to be checked. So to me, it's really a long process which, if you're just a simple person like me, chances are you just give up on the way and continue.
Any other question? Maybe you can answer that one first.
Negotiated among the member states, and mostly based on the national laws of each of the member states. So it's sort of a compromise during the discussions when the treaty is being formulated. What is acceptable? What is acceptable to other member states? Because based on their national law. Because like my colleague has said, at the end of the day, it's each country to make a decision whether that application or file for grant of a patent complies with the national law. And they differ. The national laws differ. The example, the things that are not patentable in Kenya, method of doing business, method of treatment. Some countries like US, they accept patents relating to those areas. The rest of the world, they don't, they prohibit certain types of inventions. And therefore, when you're negotiating international agreement, you have to take into account the input from the member states, because the member states can say this is not acceptable according to our national law. And that's why my colleague saying that the PCT is a filing system. You don't get a patent from Geneva. At the end of the day, it's just to simplify the process as opposed to maybe filing in the individual member states. For example, like the case is mentioning DRC or France and Germany, the national law requires that you file in their language prescribed: German, French, Chinese, all these other languages. So this tries to simplify such that for such to be carried out, it to be carried out by your national language, because there are those acceptable language you can file in. Kenya is English. So whoever is doing that search will indicate we can do such an examination on these languages. And so you'll find that once you are filing, you don't expect to find a report in French. So it comes in the language that you understand. So that is the basis, and it's a compromise at the international level when these instruments are being negotiated. Yeah, so the patent system is complicated, as you say, because it is at the end of the day, you're getting like a monopoly, and monopoly is frowned upon. We used to have monopoly, the cooking fat or the cooking oil then was Kimbo, nothing else. There was monopoly by the design of the law. And it came to a point where that was phased out. We said, let's open our economy. Let there be competition. Yeah, so those kind of things. So monopoly is frowned upon because this is essentially you are getting a monopoly in the market. You have this patent for this medicine, COVID-19 vaccine. Other players, they are excluded. They cannot compete with you. Otherwise, they would have to come up with their own invention. So it sort of tries to have a balance. Yes, the rights of the individual or the owner of the invention, and also the public
how do the public benefit from the invention? So it's sort of trying to balance all these interests. Yes, on one hand, the products we get through innovation, no, they are good. They help us to do certain things. But on the other hand, the person who invested in doing the research ought to be benefit from the input, the investment they have made to come up with those sort of technologies that are new, that are helpful. They play a role in what we do in our day-to-day life. So it's a little bit complicated, and we want to, the law requires to make sure that you are being granted a patent for an invention that is useful, that meets the requirement. All right. Any other question? Maybe.
Maybe in the interest of time, I think my colleague has mentioned what I wanted to mention. As a matter of fact, I think if one compare the traditional system of filing before, Professor, for example, the spirit of the Paris Convention was that you file all these applications individually. But in the PCT, they compromised and agreed that one single application can have effect in all those countries. So I thought it was a step in the right direction. Of course, it may be complicated for your case. But from where we came from, it was complicated. It was more complicated. You would have expected an applicant to enter each and every country, identify a lawyer to file on their behalf, pay individual fees, have as many examination reports as possible, because each country must examine. And you can imagine if you were to get examination reports from 156 countries, if you are going to file a PCT application, that was going to be a tall order. Issues of application which you must pay, that would have been very expensive, surely. So, but I think from what the PCT system has done is to collapse all these procedures in one office at the international phase. International publication, international preliminary examination, international search, you know, name it, and the processing at the international, with formal checks are done by the International Bureau of WIPO. So all these, I think from where we stand, we have come from far, but as opposed to the original traditional system of the Paris Convention. So maybe we are proceeding in that direction, but then again, because of monopolies, as he mentioned, we want to get a watertight patent application. At the end of the day, you are going to be having exclusive rights. So we cannot, I think all these things must be taken into account to ensure that you get a valid patent that cannot be infringed for a long time and you enjoy your rights. So thank you very much. If there is no other question, I think there is a presenter. I think my colleague was supposed to.
Yeah, he's here.
Where?
He's here.
Oh, no, you know, he's behind this pressman, so I could not see him.
So you're done?
I'm done. So because really, just come over. Maybe.
I think up to this point we had two other presentations that were to be done. One of them I was to talk about the TISC program. So I'll just quickly take you through that, maybe in 5-10 minutes. And then we were to look at how to search and get information and use information from patents for research purposes. As we have come this far, you already understand now that patents have technological information. And that technological information can be used for research purposes. You can use it as stepping stone to solve local problems. And this is based on something that we call the public domain aspect. When patents are filed, on the 18th month in most IP offices, the information is published. Publishing means laying the information open for anybody who may be interested in looking at that information can be able to access it. From filing until the application is published, the information is not open to the public. But after it is published, anybody has access to that information. In actual and in the real life situation today, many of the offices publish the information and put it in open databases. So if you want information on patent applications that have been published in US, you'll find them published in Japan, you'll find them published in China, you'll find them, name it. So many countries have put the patent information or IP information into the public domain. One of such system is this database maintained by WIPO. Let me just open it. So if you want to access that patent database that's managed by WIPO, we call it Patent Scope. So you can just go to Google and open Patent Scope. Just learn the word Patent Scope. You'll find that entry that comes up first there. Then you just click on it. So it will take you to this website. So from here, you can enter your search query. And your search query here probably, let's say you are interested in the area of fertilizer. The other one. I wanted to start with the general, the front page. If you look at that space where you read first, on the right-hand side field, you have the word front page, okay? But you can as well use different fields, okay? So you can use any field, you can use full text, you can search the full text, you can search the international, using the international classification, all names. For example, names of the inventor, names of the applicant. So if you click here names, you just need to enter on your right the name of the person. Let's say Michael. So if you search, it will bring out the names of probably the applicants and the inventors. So you can see in this one, where is the word Michael? Yeah.
Could be one of the inventors.
One, yeah,
Only explain one.
it could be one of the inventors. You would have to open the original document, then you have the bibliographic page. This is what we call the bibliographic page. So if you look at the names of the inventors, no, it's not among them.
Not inventors?
Yeah, there is. John Michael Owen, the agent. So it searches among the names appearing in the name. It could be the name of the agent, it can be the name of the inventor or the applicant. But that is, if you're looking for information from that point, from this page. But if you're, the best way to look for the information is to come to the advanced search. So you click on the search here and you can be able to access the advanced search. For those who are knowledgeable in how to construct queries directly, you can use that service that is available there. But for me, I'd advocate that you use the field combination. Under the field combination, here you can use the front page as well. So you can type you can say any field in the field combination. So you'll search on that front page for information. The agent will go through the front page looking for the information that you're searching. The other option is you can use a different field. For example, I can decide to use let's say the English abstract. If I'm looking for technology, I would advocate that you use the abstract rather than, let me just put it up. So you can see the Danish abstract. English abstract is down here. So now, on the first and the second row there, I've selected the field as English abstract. Here now you can select the key term that best describes the area of inventions that you want to search in. For example, let's say we are looking at, for example, in our case, we are looking at beverage. So when you learn this query like this, it's going to fetch for you all the documents where the word beverage appears. Okay? And if you come down here, you can see the office selected is all. That means we have all these countries where is it again? So you have all these countries included. Information from all these countries can be found in that database. So when you select all, it means you're searching from Aleppo, the Aleppo database. I mean the Aleppo patent information that is uploaded in this database. You have information from Moapi. You actually have some information from Kenya as well. Eh? There are some patents that we have granted or published here in Kenya which have been uploaded on that website. So you can be able to search that information. But there are millions and millions of patent documents available from this database. So when I'm searching on the abstract, I'll search, the engine will search all the abstracts of the patent document in that database and bring out all those patents that have the word beverage. So if we check down here, we are going to search in all, and what we have, we actually have 157,291 results. You can see that figure below there. Those are the number of hits that we have managed to get. So if you're reviewing a patent, this information is a lot. You can't go through that. So what you do is that on your query, you can keep narrowing by adding more terms that best define your invention. For example, I could be looking for, let's say, herbal related beverages. But then here you also have to define the field that you're searching in, and we were looking at English abstract. Could still use the English abstract. But remember, you have the option, you can even search the words in the titles of those documents. So, and if you run these, you'll find the number down here will have gone down. So we have 1,371. Let's say it's the herbal beverage that we were looking at yesterday. So we add the term. You can continue limiting by adding the term. I don't have to select a different field. Won't they be treated as the same? Yeah, but that is combination. Don't it use add? So you can continue adding the terms, but you can also even add against the terms that you have already added. Let's say ginger. So again, the results have gone down to 60. And you can view these results by the honey. Okay. So there are 70. We can still add lemon, which was an ingredient, one of the other ingredients. No, it has not even gone down. But they from 70, you see, they have come down to 60. What is happening? I've lost connection. So these are the results of our search, okay? And you can see up there at the top. I don't know where it can be. Here, this is the query that we have learned, and it says English abstract. You're looking for beverage, and English abstract. You're looking for herbal, ginger, and lemon combined. That's what I was telling you. If you put them in the same field. It treats it as a term, one term. Yeah, it does put them as a term. So any other meaning that has the individual elements separate from each other, they'll not be included. Yeah. Okay, so that is the query. So the first component that is being searched is the word beverage. But in finding the word beverage, they are also finding in the abstract where we have these three words: herbal, ginger, and lemon. Okay? So we have in our hits how many? Five results. If you want to view now the full document, you come to the number here and just click on it. It will open for you the document, the patent document that has that information. And this was filed in UK. Application number was 2020, that is the year, 01077. That is number. So you have the year and the number as 01077 as the number for that patent application. It was published as publication number 259, 1289. You can see the publication number here. Okay, this one. This is the publication number. The publication date was 28th July 2021. And there is what we call the IPC classification. Patent information is normally classified according to the field, the area of the invention. And they are classified according to the international, an agreed scheme called International Patent Classification Scheme. But recently, there was introduced what we call the cooperative patent classification, which is an agreed scheme of classification by a number of states. But essentially, they are very close and related to the other one. In essence, the inventions are classified according to their field and the area. There is a scheme that is devised and agreed on against which invention is classified. Like, for example, if you were to search using the classification, if you were to classify our invention, most likely it would belong to this very same classification. So when you're doing the search, one of the things that you take note of is the classes that come up when you, because at this point in time, I don't think you have the capacity to be able to classify patents according to the name. But you can be able to infer the class to which your invention belongs by looking at very closely resembling inventions or patents that have the classification indicated. So you can search in this similar classification. One of the advantages of using the classification is you are able to pick directly, not just a document that has the words, but a document that actually describes a very similar invention to what you're searching. So you're able to come up this document. This document, you can view the claims. This is just the front page of the document. You can view the description of the invention. Okay? A beverage tea may include mixtures of herbal teas such as blah, blah, blah. Remember? Those are some of the informations that we were trying to capture when we were doing our claims and all that. So this gives you a full description of the invention. And then the claims, a solid beverage composition. Ours was a liquid. A solid beverage composition which is really soluble or dispersible in hot water or milk to produce a beverage solid composition comprising a compressed powdered extract, blah, blah, blah. So you can get a description of the claims, and you can use this as a guide to help you when you're drafting your own claim, okay? Apart from using it for research purposes, because it describes the invention that you are looking at, you can also use these documents to guide you when you are drafting your claim. Once you are able to retrieve well-drafted patent documents, you can observe the language which is used and how it's used, and you can use the same language and terminology to do your own claims and all that. So make use of this both for research and even when you're drafting the patent. Come here, retrieve these documents and use them to evaluate the novelty and the inventive step of your application. Because once you do this search, it's able to bring to you, bring out for you all those inventions that are already in the public domain and which have, which are related in some way to the, as I said, you don't start from the zero level. You always start from somewhere, because other people, those who have gone before you, have done research and innovation in the area probably your invention belongs. You are not starting from designing the wheel. The wheel has been designed. You are building a vehicle on top of the wheels. Okay? Other people have come, they have built the body of the vehicle. So you just modify the body. You just improve on it. So this is just one of the information databases that are there. There are several others that are available. As I mentioned, there is the USPTO patent database. There is Google Patents. You are familiar with the Google Scholar. Just as you search in the Google Scholar, you can search in Google Patents. And in Google Patents, you have options to search in the various fields, the name, the classification, just as I've shown you. You can search with the keywords. I know you are used to keyword search in Google. When you're in Google Patents, you can do the keyword search. You can even search by dates. You can look at patents which were filed between this date and a particular date. And there is a guide to Google search, which is available on the Google website. So you can play about with that as well. And many other offices put that information online, so you can access it from whichever point, wherever you are. And it is, most of this information is freely available. So what I want to do, because I may not be able to get into the details of every aspect of that, I'll leave you with a guide that was formulated by WIPO on how to do those searches. So there is, let me see. Yeah. So there are these documents that we are going to send to you later, and one of them is on how to search. I've just hinted to you on how to do it. So there is the document with patent scope search. That takes you step by step and teaches you how to carry out the searches. The other document is on patent scope user's guide. So that gives you also on, it tells you about the strategies of search and how to go about it. WIPO has also developed another document, that is the WIPO Guide to Using Patent Information. How do you access, how do you answer technical problems using the literature provided in the patents? As I told you, on the 18th month, inventions are published, they are available to the public, and they are free to search and to use for research. The other aspect is, once a patent expires, that information remains available to the public. And you can actually access, use, you can find patents that have expired, access them, and you can actually work out those inventions without referring back to the inventor or the holder of the patent. Okay? If the lights have expired, and the lights can expire in two circumstances. One, if you don't pay your maintenance fee, the lights fall in the public domain, that the patent lapses. That is one instance. The other instance is where a patent has finished its term of 20 years, okay? The lights expire. So that invention is in the public domain. You can access and use the information in the patent document to make that invention, and without being asked by anybody any question. You don't have to pay a cent to do that. Just access that information, invention, and make your invention and sell it in the local market. There is also another scenario. The patents that are filed in the world today are in millions. But only a few, only a handful of those inventions do people come to Kenya and enter the national office, as Langat was saying, or pursue their application for protection in Kenya. Over 99% of the patents filed worldwide are free because there's no patent available in Kenya. So all you need is to establish, do the rights to that patent exist in Kenya? If they don't exist, you are free to make and sell in Kenya that invention which is disclosed in that patent. Okay? So you could go hunting around looking for those inventions that are out there, okay? But in Kenya, they are not protected. And you're free to make and sell, okay? In Kenya. And you will not be infringing anybody's right, because rights to a patent are territorial. So use that information for search and research. So there is also the manual that I told you. There's a copy of it, okay? That takes you through what we have been telling you for the last 2 days in more details and in very precise way. So make use of that guide as a reference book when you're drafting your patent. If you have an issue with any of the areas that we have talked about, you can always refer to that manual. This is the second edition. There was a first edition. Then it has been revised with after review by those experts in the field in the area of drafting patents. So that patent drafting manual is a very useful tool that we are going to leave behind with you. And if you have time, you don't really have to wait for the one from circulation. As some of you told me they had already downloaded, so make use of it. And with that, I think I would end that bit of the presentation. The other thing that we wanted to talk about is the Technology and Innovation Support Centers, establishing a TISC center. This is a program that was started WIPO, pursuant to the WIPO development agenda. And the purpose for which this program was initiated was to facilitate access to IP information. Because the developing and the least developed countries had an issue with accessing, especially the information on patents at that time. So WIPO came up with a program which they called the Technology and Innovation Support Centers program. And the purpose for this was to facilitate and enable those people in these developed countries and developing countries to access the technological information much more cheaply. And we signed a service level agreement with WIPO in 2011. The KIPI became the focal point for the establishment of the TISC centers in Kenya. So we've been pursuing that program since then. I think November 2018, that's when we signed with the University of Eldoret. So you are among the TISC centers by virtue of that agreement. But essentially, you are supposed to go ahead and set up that access point for that information. And the purpose for the TISC centers is to provide information. That was the basic purpose, to provide information and access to IP information. Over time, this has evolved. And because of the demand for more of the IP services, we've taken on other services like patent drafting, services related to IP management, technology transfer, matters of commercialization, and essentially the TISC centers functions have come to overlap quite a lot with the IP management functions within the institutions because of the nature of the skills and abilities required to learn TISC center and to learn an IP management office. They overlap a great deal in terms of knowledge and the skills. The skills that you require to offer the services of patent drafting are the same skills that an IP manager needs to have access to be able to prepare patents and file. Okay? Advising the innovators on matters of commercialization. The IP offices normally do those as routine services in the organization. So there is a very great overlap between the TISC centers and the IP management offices. And we have continued to encourage, if you are setting up a TISC center, you need to bring the two together. The same staffs who are offering the IP management services can offer the services of the TISC center. You know, assisting the researchers to access the information, showing them how to do it, you know, advising them on matters of IP, when to file, what to protect, how to protect. These are informations that are offered across both the IP office the TISC centers. For you to establish the TISC center, you need to alert the MD KIPI, because that is the focal point. Then the relevant officers will be made available to you for guidance. Then what we do is that we involve you in the initial first training for you to start understanding IP and all that, and even understand what you need to do to start and keep the TISC center learning. So our role majorly is to guide the TISC centers on the establishment and assist in building the capacity through training and consultations as well. Then there is the WIPO comes in in very great way in terms of capacity building. Especially those are already established, they've been undergoing training through distance, sometimes even face-to-face training on matters of IP. The facility for training is within the programs of the WIPO Academy, World Intellectual Property Academy, WIPO Academy. We call it WIPO Academy. And what happens is you apply for the courses, and before you apply, you have to open an account. Once you open the account, if you are a TISC center, you indicate that you are coming from a TISC center. And when you apply, the office does the recommendation for you. KIPI does the recommendation for the TISC centers because when you apply, WIPO asks for that certificate of recommendation. So we've been recommending those people from the TISC centers to undertake those courses. And because there is fee attached to those courses, normally what WIPO does is to waive that fees, and then you can undertake the courses for free. So this helps you to start building your knowledge and skills in IP if you are appointed as a TISC center. So I'm encouraging those institutions which have not established the TISC centers to go ahead and start off the process by actually expressing the interest to establish the TISC center. Then what follows that is we sign an MOU and we kick off the TISC center. It's a very important aspect and it's helping many of the institutions to get started on matters of IP and even kick-starting the role of IP management in the institutions. And it's open to all education and research institutions, the universities, the TVETs, even schools which have any public institution where we have works of innovation going on. Even incubation centers, if they want, they are encouraged to join the TISC network. So the institutions now which join the TISC network which join the TISC program become part of the national TISC network. And we have those forums where we exchange information. If you're facing any challenge, you can always, call a person in the other TISC center who have maybe somebody who has undergone the same challenges, and he'll be able to brief you. And I think with that, I'll bring my Nini to a close. I don't know whether there are any questions. Nimekimbia haraka sana mpaka hamkunisikia.
to have a quick question on the centers that you are talking about. First of all, I don't know if there are some basic requirements for an institution to qualify so that you can have an MOU with them. Secondly, on the number of staff, also an issue of the cost involved, if there is any cost involved, and lastly, perhaps on the duration that it can take.
There's no cost involved, that is one. The TISC program is open to all public institutions. Okay? To any government or to all public institutions. Government parastatals, TVET, universities, okay? All those involved in research and innovation. You can establish a TISC center if you want. As far as the cost involved, it's the cost of availing the space, internet connectivity, and at least the staff. Because a TISC center will not function if there is no person. The knowledge on how to search, how to draft, file and prosecute IP applications can only be built in a person, not in a room. So there is need for there to be, staffs dedicated to provide the services at the TISC center. It may be on part-time, not necessarily full-time. Okay, it could be on part-time basis as an additional responsibility to a person within the organization. So that person learns and is able to help the others to access and to be able to use the IT system. Right? I don't know whether that answers your question. Okay. The duration of? Initially, actually, this was started as a project, but it has been mainstreamed as a work program within WIPO after the demand for the services, the countries expressed the need to extend. So the time limit for the end of the program is not defined as yet. So it has become like a continuing activity that should be mainstreamed into, the day-to-day of all the organizations. And again, even if the program would come to a close, the TISC center is actually owned by the institution that establishes it. It's part of, like, for example, if I think the Eldoret National Politics, we have one there. Let me see. These are the institutions that have already established the TISC centers. We have signed the MOU. If, in the University of Nairobi, the TISC is learning. In Jomo Kenyatta University, the TISC is learning. And essentially, as I said, this belongs to the institution. It doesn't belong to KIPI. It doesn't belong to WIPO. KIPI and WIPO are only providing support services. The services that the TISC center offers is consumed within the organization and the surrounding innovating communities. Those that you interact with another. Those are the consumers of the service. And you can decide, there are those who have done it for, they levy fees on the services they offer. For example, if an inventor out there comes and wants assistance in patent drafting, some of those developed TISC centers, they actually charge for such services. But you can decide to provide it for free. It's not the comment that you do, you raise money with the services that you offer. Because actually even the greatest number of consumers are those who come from within the institutions. These are the other institutions in the TISC network. And in total we have about 15 of them in Kenya. In fact, we were thinking of organizing a national meeting for all those institutions that have established a TISC center, so that we get now to interact on a face-to-face level and start discussing on how to move, how to kick-start the network and get it moving to the next level. But as of present, we have about 15 institutions that have already established the TISC network, including universities and technical institutions, or institutions of technology. But it's open to any R&D institution that wishes to establish one. Okay, thanks.
Thank you for the presentation. I have some few concerns. Now we have been training on the IP. From your point of view, what are our roles? By the fact that now we have undergone training on IP, so from the point of view and the issue of TISC, what are our roles in the institution in relationship to establishment of TISC, so that when we go, we have something to report or to follow up, so that maybe if one indicator is establishment of TISC, and from here you maybe have given us, or you've given us a recommendation to recommend to our institutions, so that we look a way of signing an MOU with you, so that it can be established. Or else, we may be attending this IP, you speak about it, we don't have a criterion of following it up to ensure it is established. So I think maybe if you can emphasize that as we are reporting, it should be one key thing that we must advocate for.
Okay, I think the first step that you can take is to, you have heard what TISC is and what it does. The first thing, if you want to establish a TISC, it's to express that interest in lighting. Okay? So that is the first step. That initiates the discussion now between us and the CEO, KIPI, and the CEO, the other side. Okay? The principal. Now they can start talking on one-on-one how to proceed to get it up and running. And usually what we do is that we can have a sensitization, an allowed table discussion on the same. Once it's agreed, the next thing is to sign the MOU. Essentially, it's a template, just like the one that have been signed with these other institutions. And once we sign the MOU, it's upon the institutions now to set up the space and dedicate the staff. Okay? Once the staffs are, we know who is the TISC staff or who are the TISC staff. Whether they are on part-time or full-time basis, not much difference. Whether to be on full-time or part-time, that one is determined by the demand for services. We don't actually at first insist on a person being put there full-time. It could be part-time basis. Okay? Just like you are serving in which institution?
Baringo Technical.
Baringo Technical.
Yes.
You could be carrying this as an added-on responsibility or job to your post. once the demands of services grow, and you have to be on this most of the time, okay? Because what will happen is the demand of services, as they grow, they start pulling you from the other responsibilities now. You find you're spending more time at the TISC center, not with the other responsibilities. Then you can move to full-time person, or you get more added people doing on part-time. So when you are not available, there's somebody else who is available to do to provide the services that are supposed to be provided from the TISC center. I think those are the key stages. For now, just go and front the idea to the VC, to the principal as you report. Then you can impress on him, to try to keep it to say, just expressing the interest that you want to establish a TISC center. And then from there, the MD will get back to you, probably with a template of the MOU to review and agree. Once you agree, we sign, we launch the TISC center and move.
And again, do we have, now we are sensitized, do you have a mandate to sensitize fellow staffs on the same issue?
Yes, yes. We are open. Anytime you call on us, we'll come.
CC, let's say we have now the knowledge. Can we have maybe identify some staff? For example, we have personnel who train on trade projects.
There is no monopoly on IP knowledge and information. Just go ahead and disperse, share. Okay, because even if you don't share, this information is already available in the public domain. Share with your colleagues, share with those people you think they can form part of the TISC staff. Please, you're welcome to do that.
Okay, thank you. I think the last questions are really setting now the pace for more interactions, maybe over lunchtime. And sadly, they normally say that as you get near the end of an activity or an event, you find that there are more interest now coming up, and people want a lot of follow-up questions, a lot of interactions. So nonetheless, I think we are actually limited by the program, because as earlier communicated that we'll need to, to close this session. At least we were thinking of 1 p.m. so that we have 1 hour lunch and people can leave at their own pleasure. Nonetheless, I would like to say thank you very much, especially for the facilitators, as well as you participants for being keen and also participating. My role now is to call upon the people who will give more value in terms of, who will give the vote of thanks, and I will have the vote of thanks from the University of Eldoret. And there will also be another vote of thanks from institutions who have joined us today. Ideally, because of interest of time, I will have asked the participants to say the key messages that are taken home. But because we really believe and feel like participants have really earned a lot, because this is more of actually sensitization, which has really gone to another level of giving us more of hands-on on how to do it and where to get the resources. So I really thank you very much for this creativity. So let me invite Prof. Lizzie Mwamburi from the University of Eldoret to give her vote of thanks, who will welcome our colleague from the other institution also to say their remarks and vote of thanks. Thank you very much, Prof.
Thanks. Okay, so today I'm only going to speak on behalf of University of Eldoret, and I expect the other institutions to speak on their behalf. I don't want to speak on behalf of anyone else. Okay, so on behalf of the University of Eldoret, we are very grateful to our facilitators for being here and accepting to come and facilitate us and sensitize. Actually, you've reached a wider audience than you can see in this room today. And I also want to thank those other institutions that joined us for coming and gracing this occasion and making this training very, very interesting and very interactive. We look forward to interacting with you once again, as we have discussed with several other participants who are here, that the next sensitization is going to be in one of the other institutions, not here. So when they invite KIPI, we are going to be there again. You will see us there. So thank you very much. I'm sure our participants who are online also are very grateful, because the feedback from our online participants has been that this has been an eye-opener. They didn't know that what they actually have on their desks is actually patentable, and they actually are very grateful for this training. So I am going to request a participant from another institution that is represented here to come and give their vote of thanks on behalf of the other participants. So I don't know who that is going to be. So maybe you can introduce yourself.
Okay, thank you, Prof. My name's Dr. Kenneth Sirma. Come from Turkana University College. I'm alumni of this institution. Professor Mwamburi was my lecturer. Professor Luther. So I have a lot of, I'm so grateful to be here because I have met my mentors. And just to the point, I've been told to give a vote of thanks on behalf of all the institutions. I may not name all the institutions, but we are grateful for this opportunity to KIPI, Paul, David, and yeah, also for the other ladies, 2 ladies from Kekobo, and KFIS, I think it was Violet and Emily. I can't get all the names. We are grateful for that opportunity. Also, University of Eldoret for this opportunity. This training actually has made me understand. I had a different perception on the IP, but I think now I'm understanding a lot of things which I had my own perceptions about, on how to draft an IP and the rest. We are so grateful for this opportunity, the technical staff, also the other staff who has made us comfortable for lunch, tea break. We are so grateful. Sometimes, huko nyumbani hata you might not take tea at 10 or at 4 o'clock. But here we are more grateful, we are comfortable, and I think we shall go back home or to our institution and inspire the rest of our scholars, innovators, to come up with innovations and to have their innovation patented. I don't know, there's a guy from Kericho who has made up a vehicle with a truck, an hydraulic truck, and I was thinking this guy might not have even patented, because actually he has done it from scratch, though he has used parts of other vehicles like Toyota, Nissan, and the rest. So maybe it is up to us that we come from those villages, from those institutions, to make them understand that what you do locally there is very important. That innovation that someone does, he or she can protect it, and maybe, as Chege mentioned, the nice and lovely experience, maybe after 5, 10 years, the guy might be a billionaire. Yeah, so maybe it's also upon us to go and educate the rest of our colleagues and also the society through community outreach and the rest. So we are so grateful for that opportunity. Thank you.
Thank you very much, Dr. Sirma. I didn't know that I taught you, but you're welcome. So I think I'm going to give the program back to Alkamoy, who is going to invite our corporate affairs manager to come forward.
Okay, thank you very much. Now we are transitioning to another session where I want to invite the corporate manager. Please come forward. Okay, now you can.
Okay, good afternoon. I come bearing good gifts. So again, we are very thankful for the 5 days that you have been together with us. I believe those that have consistently been here have learned a lot. Some of us who have been all over have also learned quite a bit, and we are truly grateful. I stand here on behalf of the Vice Chancellor, and I would like to just give you a token of our merchandise so that as you live here, you will continue promoting brand UOE and of course marketing for us. We are told we have to declare what is in here. So this is just a mug that is branded, which you can use for your coffee or tea, your preferred beverage. So that we have evidence, I'm going to invite Professor Balozi to just hand over the gift to you. And then we will invite the representative of the other institution. That is the guy from Turkana who gave the vote of thanks. We'll also received, so please come. Prof. Karibu. So we'll start, just the way you are seated. You know, we want to do an individual photo so that we can put it on our website. So Prof, please hand over. So Karibu, enjoy.
Yes, thank you very much.
Thank you very much.
Asante sana.
This is home.
So thank you, Prof. For the other members represented here, there's always a next time. So today we'll end it there. I wish we had enough for everyone, but I hope you take it in good faith. Thank you.
Thank you so much. So now I'm going to invite Professor Balozi to close this meeting.
Assalamu alaikum wa rahmatullahi wa barakatuh. Good afternoon. I know that's a greeting in Arabic, and it means may the peace of God and his blessings be upon you. So don't freak out, it's just a language. When Dr. Nganga said she had gifts, I thought, wow, Christmas is early this year. And then she just gave a sample. But that's appreciated. Yes, colleagues, trainees, and the lecturers, good afternoon once again. Yeah, I want, before I go to my short speech, I want to appreciate all of you, and I believe that we have actually learned a lot here, and so that it doesn't get lost in the speech, let us also practice what we've learned here. Okay? My name is Professor Balozi Bekuta. I'm an alumnus of Moi, so I think we are connected with so many people. I didn't know that. Okay, Professor Liz, the others, and of course, I can see also Professor Mwasi is here. We were all together. You can imagine. Ah, yes, yes. Many more here. All right, yeah. So it's great to interact, and please allow me to read my brief speech. The core business of the university is to provide training and carry out quality research, and more increasingly nowadays, innovations as well. The results should be disseminated to users and thus create an impact, a positive impact, on the development of the country as well as the individuals. In line with our core values at UOE, integrity, innovativeness, equality, inclusivity are key ingredients. A lot of worthy research has been accomplished, but sometimes the results hardly benefit the researchers or those who've actually put their brains to bring those ideas and the products. So it is good to know that we've learned actually of ways so that we can also benefit from our intellectual ideas, as well as our research that we do. This course on drafting and prosecuting patent applications has come at the right time and built our knowledge on how to protect our intellectual property. You will agree with me that after these 5 days, where we've just learned a lot, these 5 days of experiential learning, we now better understand intellectual property rights, patents, and utility models protection, copyrights, and related rights, plant breeders' rights, trademarks, industrial designs, patent drafting, filing of patents, application, and protection, and also using patent information for research. Thank you very much to our teachers. I believe that with all that we have learned, we are now better placed to carry out our research and innovations and be able to protect our intellectual property. Allow me to heartily thank KIPI, Kesobo, KIPI staff for enlightening us on IP. I request you clap, please. I take this opportunity to also recognize and appreciate the participants from the various institutions that have joined us. Those who are physically here, as well as those who followed this training virtually. Our staff at the university, especially the Directorate of Research and Innovation, and in particular, Professor Liz Mwamburi, Tim, Mr. Alkamoi, and Dr. Nganga, and all of us, the others, really appreciate you for tirelessly working and going out of your programs to make this a success. Guest house. were also very, very important for taking care of our gastronomic rights during the training. I think that's one right that I knew, but now I've added on to that, okay? The Office of the DVC, PRE, and the VC, Professor Teresa Akenga, for their support to conduct this training. It is Nelson Mandela who said that education is the most powerful weapon that one can use to change the world. Let us use the knowledge that we've gained from this training to benefit ourselves, our institutions, and our country. With these many remarks, I declare the training on IP drafting and prosecuting officially closed. Thank you.
Unfortunately, when it is closed, we can't talk anymore, isn't it? But it's just a request that we need a group photo with our facilitators and all of us, kindly. And I will take this program to the photography team who will guide us. And then lunch is ready. So let us not leave without taking our lunch, please. The voucher is still very valid. Thank you very much. Okay. So you can guide us, either we go outside here or we go